Hello, my name's Lisa Kinder. I'm an LGFS caseworker and I've been here for about a year and a half. And today I'm going to be taking you over some hints and tips for when you're submitting your claim on CCD. Now, we haven't created a complete start to finish guide. However, if this is something that you think would be helpful, it is something that we can have a look at doing in the future. So instead, we're focused on areas that we feel receive the most appeals and queries on. And the area that we do receive a number of queries on and sometimes get bills submitted incorrectly are claims that aren't final fees. So this would be interim claims, transfers or hardships. So in order to set up these types of claims, you'd first need to select the appropriate option from the choose your bill type window. Then from these options, you can then select the appropriate claim that you wish to create. So by selecting the interim claims option, this will allow you to then set up either an effective PCMH, a trial start, an interim disbursement or a warrant fee. Something just to be aware of when you are setting up an interim claim is that you would need to select the case type as either a trial or a retrial. Now, this doesn't mean that it will calculate the fee as a trial fee, and you will be able to select the type of fee you wish to claim later on. So like other interim fees, warrant claims can also be found in the interim claims section. One issue that does occur when setting up a warrant fee is that the system may not let you proceed with your claim without entering an execution date. So if the warrant is still outstanding, you can enter a dummy date and this should let you proceed with your claim. You would then just claim a fee based on the stage that the case had reached at the time the warrant was issued. So when it comes to transfer claims, if representation has transferred at any stage, these fees would need to be set up and claimed as a transfer fee. The type of fee you claim will of course depend on what stage the case has reached. So the following trial fees can be claimed for the original litigators. And these are up to and including PCMH transfers, before trial transfer, during trial transfer, a transfer before retrial, a transfer during retrial, and a transfer after trial before sentencing. So for new solicitors, as well as these transfer scenarios, you'll also be able to enter the type of case claimed based on the way the case concluded. If you'd like to take a look at slide 14, you'll be able to see an example of how to submit a transfer claim. So when you do come to submit a transfer claim, there are a few essential points to be aware of. So when entering the representation order date, this should be the date of the original representation order that was granted. And if you are able to, please provide a copy of the transfer representation order in the supporting evidence as confirmation that the transfer has taken place. This will help us to prevent any delay in the processing of your claim. Also, you would only be able to claim the amount of PPE served up until the point of any transfer. Any material served after this date will not be payable. So supporting evidence, when it comes to supporting evidence for your claim, this can be uploaded using the Upload File tab. When uploading supporting evidence, it's a good idea to utilise the checklist and tick off each piece of supporting evidence that's been uploaded. Firstly, this helps you to keep track of any material that you've uploaded and if anything has been omitted. And it also helps us to know what material has been uploaded to the claim when we do come to assess it. Additional information, there is a section for you to utilise the additional information section. So particularly if there is a more complex element that requires further justification, you can use this section to detail any extra information in support of your claim. This can be really helpful for the assessor as it can clarify why a specific aspect of your claim is being claimed, or alternatively, you can upload a taxation note. And we also have a messaging facility. So once you've submitted your claim, you can utilise the messaging facility. This can also be used to clarify anything with your claim. In addition to this, if you have omitted all or some of your supporting evidence, this can be attached to a message. However, please be aware that only one file can be attached per message. So if there are multiple files that you would like to add, you would need to send a corresponding message for each file. And now I'll pass you on to Nicholas Stevenson.
Hi, my name is Nicola Stevenson. I am a senior in the Litigator fee team and I have been currently doing my role now for 11 years. Today I'm going to be running through interim and transfer claims. This will be from slide 20 to 27. So interim fees can be claimed at a different stage in the case. These include an effective PCMH, a trial start, and if a warrant has been issued. So how do we determine what an effective PCMH is? So this can be claimed after an effective PCMH or PTPH has taken place, whereby the defendant has entered a not guilty plea and has been arraigned. It is important, however, that if the case was only listed for a PCMH, but for whatever reason did not take place and was not effective, with no pleas entered, no fees can be claimed. A fee would only be considered payable if the PCMH was effective. So how do we determine what is a trial start? This can be claimed once a trial has started and has been estimated to last for 10 days or more, and may be claimed any time up until the trial conclusion. An effective trial start is where the jury has been sworn and put in charge and the prosecution has opened the case. If the criteria has not been met and the trial does not appear to have commenced, then no interim trial start fee will be payable. However, if you've not had a claim for an interim effective PCMH already, then this is something that you can look at claiming. Moving on, I'm going to speak about warrant fees. So a fee can be claimed where the warrant has not been executed after 3 months since it was issued. Here you can claim a fee based on the stage the case reached before the defendant absconded. So where a warrant fee would not be payable is if a claim is submitted within 3 months of the warrant being issued, this would then be refused. Additionally, if a warrant is executed within 3 months, then the case will continue as normal and the claim should be submitted after the case is concluded. So the usual case proxies will apply to your fee based on the offence class and the number of defendants and the number of pages of prosecution evidence served at the time. So any fees paid at the interim stage will offset against the final fee payment. So I'm going to give you a little bit of an example here. So if you've previously been paid £250 and the new fee would be for £900, you would only receive an additional £650. So the fee would offset against that. So as you've already had £250, you'll only get £650, which would total to the £900. The fees paid to the litigator will also be varied by the offence class and the number of defendants. The fees will also depend on the number of pages of prosecution served at the time. The amount payable for the first interim payment after PTPH or further case management hearing is 75% of a correct trial fee. This is based on PP served at the time. Also, if you have a second defendant, then the defendant uplift will apply, or if you had a third defendant, so on. The fee paid for the second interim payment, which is a trial start, will be paid as a 1-day trial, plus PP served at the time. Also, if you have another defendant, or if you have 2 defendants. So uplifts for additional PP served days at trial and the defendants will be claimable when the final claim has been submitted. Additionally, if the offence class changes, it will amend at the end of the trial upon submissions of the first claim. Just please note, upon billing the final claim, any payments made as an interim will offset against the final fee payment, as I've previously explained. So moving on, I'm going to speak a little bit now about transfer fees. So I'm going to give you a little bit of an overview. So if a case transfers from one litigator to another, a fee will be payable depending on what stage the case has reached. So the original litigator received partial payment depending when the transfer took place. The new litigator received a full transfer graduated fee payment. So the term transfer has been extended to include the grant of the representation order to an individual who immediately before the grant of the order. So they've either represented themselves or have been represented privately by a litigator named on the representation order. Additionally, at any point legal aid is withdrawn, this would also be considered a transfer. Therefore, a fee would only be payable up until the case is transferred or withdrawn. So I'm going to go over a couple of different types of scenarios. I'm not going to go over all 12 points with you, but I will give you a few examples. But if you do want to refer to the scenario types, then you can look at slides 24 to 27. So we have transfer during retrial new, is where the case transferred partway through the case, the new solicitor can claim for all the trial days that took place once they became instructed to the case. We also have transfer before sentencing, original. This is where the case has all but concluded and the case is transferred away before the sentencing hearing took place. We have transfer after trial before sentencing new. This is where the case is concluded, but the case is transferred to a new solicitor and sentencing hearing has taken place. So these should clearly set out what fees can be claimed depending on the stages the case is reached at the point of transfer and if you are the original or new litigator. So in relation to supporting evidence for transfer claims, if you have a copy of the transfer representation order, this will help us to determine when the transfer took place and verify the stages that the case has reached at the point of the transfer. If we're unable to determine the transfer has taken place, we may request further information to be provided. Here is the easy ways for us to verify this information is by yourself providing a transfer representation order to us when you're submitting your claim. Further guidance on transfer scenarios can also be found in section 3.13 of the Crown Court Fee Guidance, and this can be found in the link attached. So what we're going to do to help reduce redeterminations. We are enabling our caseworkers with tools to assist in improving their knowledge and understanding and consistency to prevent redeterminations. So we have a thing in place called soft reject process, which I'm sure you're all aware. We have implemented this process. Basically what happens is if we are requiring further information, we will send you a message on the CCCD facility. What we will do, we will wait 48 hours for you to respond. If we've not heard anything within 48 hours, we will either part assess your claim or return your claim as refused, depending on what stage the case is at. Please note, this is not, this is classed as working days. So it'd be Monday to Friday. We don't include weekends within the 48 hours. Please, can I also ensure that your email details are up to date with the CCD team, so you are able to get the reject notifications. If the defendant is also on the same count, we will pay as per the co-defendant on the electronic evidence when possible, but please ensure that you provide us with the co-defendant's case numbers if they are known, as they may differ, and it can be really difficult to find this information if we haven't got that in front of us. We also have the access to digital case system and egress access. We have more access to the Crown Prosecution Service and court systems to reduce double handling for you and ourselves. However, if you wish to have access to deal with the claim, you would need to provide us access individually. So what we'd have to do is we'd have to let you know when the caseworker has the case, and we will provide you with our email address for you to add us onto the case. So I'm going to go and speak a bit about ethos and around part assessing claims and soft rejecting for evidence. So our aims are to ensure that we get it right first time. We provide excellent customer service and we are responsive to the information we are given. As a result, we will always pay as much as we can on the evidence that is available to us on the CCD system. So the graduated fee is driven by 5 proxies. If a piece of information is missing that prevents us paying a sum, we will soft reject for 48 hours and wait for further information. So the reasons for why we will soft reject your claims. So for example, we have no indictment attached. Please note the LEA do not have automatic access to the DCS system without provider grant access rights to an individual. Please upload a copy of the indictment to CCD. Incorrect MAT reference number provided. We need confirmation of the correct MAT number to ensure the correct final defence costs are attributed to the correct case. And for an audit trail for the National Audit Office, which in turn prevents any duplicate payments being issued. We also will soft reject for incorrect MAT reference number provided, incorrect case number, and no amending transfer representation orders attached. If you are claiming a transfer fee but unable to verify at what point the case is transferred, we may ask you to provide a copy of the transfer representation order. Please note we do not have access to the Crown Court system. So, for the following reasons, we may soft reject also in relation to electronic material or if the evidence has not been uploaded to Galaxy. Also, we may ask for proof of service, submissions, a copy of the LA report, or a detailed breakdown on Galaxy of what electronic evidence you are claiming. So, for example, by file, tab, and location, in order to make it a lot easier for us to locate your claims. We will endeavour to make a payment based on the evidence provided. Please note, most claims are part assessed for lack of additional information. So, no evidence of PPE, for example, legal aid report, an NAE, or a paginated list. Please note, caseworkers do not have access to the DCS system without provider granting access rights to an individual. So I'm going to speak to you a little bit about armed robbery. So no evidence of an offensive weapon being used. So what we would require to confirm an armed robbery would either be a prosecution case summary or a police report or a forensic report. Facts that will be considered is the primary purpose of the object to cause injury? Did the defendant bring the object with them or did they find it at the scene? Has the object been adapted for the purpose of causing injury? Is the object capable of causing serious or long-term injury? Please note, most claims are part assessed for the lack of additional information. So I'm going to speak a little bit about value based on dishonesty offences. So that's theft or fraud. And that can either be offence class F, G or K. So if you've not provided any of the evidence to support the value exceeding 100,000, then it would automatically be allowed at an offence class F. You can provide the following to support the value. So a prosecution case summary or a police or forensic report. Please note though, when you do send that information in to us, if the case summary is 40, 50 pages long, if you can direct us to where the value of the sums are, which will make it a lot easier for us to locate. As you can imagine, reading through the whole case summary to try and find the value is quite time consuming. So if you can highlight those sections or direct us to which pages to be looking at, that'd be great if you can put that in the additional comments for us also. We also have out of time claims. So if your claim has been submitted more than 3 months after the final hearing, please provide justification for the late submissions. So if you've not provided any justification or insufficient justification, we will assess your claim down with an out of time reduction, depending on how long the claim has been out of time from. Transfer fees. Please ensure you're using the correct claim type on CCD. Choose your bill type, litigator transfer fee, but please refer to slides 13 and 14 and that will assist you with selecting that information. If claims are submitted to the incorrect queue, payments may be delayed and this could be registered as a duplicate claim and been refused. So I'm going to pass you now over to Lisa, and she will go over supporting information.
Hi, so I'm going to be taking you up to slide 36. So firstly, as you'll know, most offences are classified on the table of offences. However, there are a number of newer offences that are yet to be classified. So in these situations, a Class H should be claimed for. If you do wish to request a reclassification, you are able to do this on redetermination. However, please provide an explanation as to why you believe the offence should fall within a higher offence class. Also, if you can include any police reports, case summaries or witness statements to support this, that would be fantastic. Now, when it comes to trial types and length, the number of trial days listed on CCD may not be sufficient in itself for us to verify the trial length and type. So we do verify our claims against available court logs. However, these are not a verbatim record of proceedings. So what do we need to consider? What dates are you claiming for? If you can include the dates of the effective trial days that you're claiming for, this really helps us to cross-reference records to help avoid any potential delays. Also, what type of trial are you claiming for? Newton hearings, these are treated as a trial when they're effective. And the trial length will be the combined length of when the guilty plea was entered, plus any additional days that the hearing lasted. And then we also have fitness hearings. These are video recorded cross-examinations under Section 28 of the Youth Justice and Criminal Evidence Act 1999. And lastly, we have mode of trials. So we will, of course, endeavour to validate the mode of trial against court records. However, if this is unavailable, we will pay an elected fee until we receive confirmation from the court. However, please note that this only applies to representation orders up to and including the 30th of September 2022. Now, there may be times when we will need to contact the court directly to establish the mode of trial and obtain any supporting evidence. And what we are looking for is the sending sheet to confirm that the Crown directs trial by jury. Now, please note, we cannot accept sent to Crown Court as this is insufficient to confirm how the case was sent. So I'll now pass you over to David Cook.
Okay, thank you both. My name is David Cook and I'm a senior caseworker in the litigator fee team and have currently been with the LAA for 5 years. Today, I'll be covering disbursements and pages of prosecution evidence and how you can avoid your claim being rejected, refused or part assessed. First, we have interim disbursements. Right, interim disbursements are how you receive an early payments for your experts. For us to pay an interim disbursement, we will require the following steps to be taken. First of all, you need to know if you are eligible to receive an early expenditure. When it comes to interim disbursements, you are only eligible to claim them if they are over £100 and have a prior authority in place. Meaning before you go through our system or application process, it is mandatory for you to go through the criminal finance department to have them agree a quote from your desired expert. If/when you receive a prior authority, you may submit an interim disbursement, but make sure you attach a copy of said prior authority and the invoice. From there, we will assess/pay the early fee. Whilst this is a simple process, we also ask in cases where you receive interim disbursements, you do not include them again in further submissions. For example, when you make further interim requests or at the end of the case when you bill your final fee. The reason for this is to ensure you don't incur duplicate payments and make it easier for the caseworker assessing future claims under the same case number. Moving on to travel in disbursements, when you claim an interim payment for a disbursement, you can claim reasonable travel expenses for the expert. Travel disbursements and VAT can be claimed in addition to the sum granted for prior authority. All we ask is that you provide valid receipts and/or tickets. Moving on to disbursements, when you are claiming them on your final fee, the rules change a bit and you are now eligible to claim disbursements under £100. When it comes to billing lower cost disbursements, we just need you to provide an invoice or receipt depending on the expenditure. We also ask that you provide written reasons in the additional information part of your application, giving additional context as to why said disbursement was relevant to the case. It does not have to be super in-depth, but context helps when a caseworker is assessing your bill. You can, of course, still bill disbursements over £100, but the rules don't change. We still require a prior authority and invoice, and as stated before, written reasons go a long way. Lastly, a second friendly reminder that if you build an interim, do not claim the interim again at the final stage, as it creates more work for you and the caseworker. We take duplication very seriously and will just reject any work we have paid before. Lastly, the travel rules I stated on the last slide, or the last topic in interim disbursements, still apply when claiming disbursements at the end of the case. Now I'll be talking about travel justification you need to provide on claims submitted. Travel justification has been quite lax over the last couple of years due to COVID restrictions, but we have now begun to assess them in more detail and revert to the old way of assessing travel. When we go to assess travel, we always pay travel to HMP at 45p per mile due to most prisons being a distance from rural areas. If you are claiming the standard rate of 45p per mile, you must provide reasonable justification in the additional information section on CCD. In instances where there is no justification for the use of private motor vehicle, we will pay the public transport rate of 25p per mile. Due to the volume of claims we receive, the LAA has agreed that the onus is on the solicitor to provide relevant justification for the private mileage rate of 45p. The greater the distance, the greater the justification we will require from you. If travel has been claimed regarding court hearings, we will make sure a court hearing is taken place. If there hasn't, then we will refuse the mileage. The last thing to note is regarding conferences with clients far away. The onus is on the solicitor to provide justification while they are representing the client, and a more local expert could not be instructed. Depending on your reasoning, this kind of mileage can be refused or paid. And lastly, for me, I'll be talking about pages of prosecution evidence, otherwise known as PPE. PPE is the most arduous part when we make any of our assessments, provided you have claimed PPE over the cutoff for said offence class. When we go to make our assessment, we first check to see if you have provided an LAA report or an NAE report. Depending on which you have provided changes the scope of how we approach assessing your claim, as PPE is the reason most claims get part authorised, and our hope for this webinar is to help address what we are looking for when assessing your claim. If you have provided an NAE report, then our assessment tends to be made easier, where you are only claiming exhibits or statements. However, in cases where you have listed numerous pages of electronic evidence, it is important that you select the yes option under the will you be sending electronic evidence for this claim. Failure to do so will result in your claim being part assessed, and you will be asked to submit a redetermination for the electronic evidence to be reviewed. The reason that ticking that box is important is because it's a very common reason for either delay or reduction. If the option was ignored, this is because we have been trained to not check electronic material via Galaxy Key or egress if the box isn't ticked. Additionally, it ensures that the claim goes to the appropriately trained caseworker that deal with electronic evidence, and as a result helps us process your claims as quickly as possible and streamline the assessment process. Now, when it comes to the LAA report, we are going to check the following sections. Section G to L, we will usually prioritise whichever variants of witness/exhibits you have claimed and assess accordingly, but never both. So you can either claim your section G and H together or I and J together, and we will assess based on the one you are clearly claiming. Then comes the actual assessment. You may believe we are being petty when you receive your claim back with one PPE missing, but that's just what we are trained to do. We've been trained to pinpoint the following, as they are not payable. Firstly, cover sheets. They are usually listed as the title of a section. Multimedia evidence, otherwise known as MME. BWV documents, sometimes bundled together with MME. And lastly, duplication. We're becoming more unified at checking reports and ensure you are not claiming PPE for reviewing the same work, even if it's months later. We cannot allow the same work twice. Thank you for your attention. I'll be passing it back to Nicola now.
Hi, so as you know, my name's Nicola. I'll be covering slide 44 to 48. But as David has touched upon slide 45, I will go straight on to slide 46. So I'm going to be speaking about electronic material and supporting evidence. When claiming for electronic evidence, we require copies of the material to be provided for a qualitative assessment. So these can be uploaded to secure file exchange, which is known as Galaxy Key, or if you're unable to upload this, you can send this on disk, USB or hard drive. It is essential that any removable media that is sent to us encrypted in order to comply with the data protection legislation. Failure to encrypt the data or media provided will result in us being unable to return the material to you. We will retain the media for 28 days from the date of processing, and then we will destroy the claim. If you still require the removable media to be returned, it will then be your responsibility to arrange collection in person or delivery by secure point-to-point courier. So we would recommend, if possible, that any electronic material is uploaded to the secure file exchange, as this can reduce processing delays, prevent security issues, and cut down on postage cost. If the material has been uploaded to GalaxyKey, please put a brief note on the additional information section or a taxation note explaining the evidence is on GalaxyKey or the evidence has been sent in the post. And also, if you send it in the post, can you just please put a little note on the date that you've sent it? We also require submissions to be provided on the material, so we can consider the PPE. This should cover how the material was relevant to the case and how the material was relied upon by the prosecution. It is important that if a phone download is being claimed as PPE, we would require you to identify which sections from the download are being claimed and how these would be considered relevant to the case. If it's not clear how certain sections of the phone download are relevant, these may be removed from page count. In addition, the submissions, a copy of the case summary of prosecution, an opening note can be used to highlight the material that was relied upon by the case. If you're claiming electronic evidence based on the co-defendant's assessment, it is important you still provide submissions on how the material is relevant to the case against your defendant. Submissions can either be provided in a taxation note or in the additional information section. Also, if you have forgot to put it in the additional information section, we do have the messaging facility that you can send a message across, as Lisa explained previously. We also require proof of service, and that can be in form of an NEE, LAA report, paginated list, a letter from the CPS, or multimedia egress links. We'll also be able to accept emails from the CPS prosecution authority if they confirm the material was served as used evidence in the case. We require a breakdown to be provided of any material claimed. These should itemise the material provided and clearly set out what is claimed. This should identify any folders, subfolders, detailing the material claimed from each of them. This is really helpful when material is particularly vulnerable and separated into a number of folders. If large sums of material are provided and it's not clear what's being claimed without a schedule, this may result in delays in the assessment process or part assessment of your claim with a refusal of the electronic material. It is really important if you can provide this breakdown. I just want to give you a bit of an example. So if your electronic material is over 50,000, 60,000, and you provide all that evidence on GalaxyKey to us, and there is a large number of files within subfolders, if you provide a breakdown detailing, and we can see actually we've got two files, one's got 6,000, one's got 11,000 on, we will automatically go to the bigger files to get to the 10,000 first. So if a phone download is provided, we would require a breakdown of what sections are claimed, and this also can be tied in with the submissions explaining how certain sections would be considered relevant to the case.